Okay, I hit the wrong button there, and so this is probably going to be a two-parter. If you missed the first part, this is about motions, motion day, part 2. So the motion we're trying to do is really, the idea is to be out in front of this stuff and not after the fact, like you've, somehow got yourself to be already appeared. You want to get it all at the first, at Jump Street from the beginning. And so they had this process called a demurrer. It's an allegation of the defendant which, admitting the matters of fact, alleges by complaint or bill to be true, shows that they are therein set forth, they are insufficient for the plaintiff to proceed upon or to oblige the defendant to answer. Right? So they're not good enough to make you answer. Or that for some reason apparent on the face of the complaint or bill or on account or omission, some matter which ought to be contained therein, or for want of some circumstance which ought to attend thereon, the defendant ought not to be compelled to answer. Right? So we're trying not to answer, but we do need to appear. The formal mode of disputing the sufficiency in law of a pleading of the other side, right? So first of all, we want to appear to get their pleading, to get the real paperwork they're putting in effect is an allegation that even if the facts are as stated in the pleading to which the objection is taken to be true, yet their legal consequences are not such as to put demurring party to the necessity of answering them, proceeding further with the cause. All right, so they stated a bunch of facts that really have no reason. Okay, well, what's that got to do with me is what it comes down to, right? You stated a lot of facts. What's the point? An assertion that a complaint does not set forth the cause of action upon which relief can be granted. Now, I know people have heard that before, right? You fail to state a claim upon which relief can be granted. Yeah, that's what you can use against them. A legal obligation or a legal objection to the sufficiency of the pleading and attacking what appears on the face of the document. So, demur to the evidence, like they haven't given enough evidence. By federal rules of civil procedure adopted in a whole or part in most states, demurrers, pleas, and exceptions for insufficiency of pleading are abolished. Well, it means they came up with something else to use besides that. And every defense in law shall be made by motion or by answer. Motions going to jurisdiction, venue, process, or failure to state a claim, just like a demurrer, are to be disposed of before trial unless the court orders otherwise. Objections to the pleadings by means of demurrer still exist, however, in certain states. And I've seen that, you can find that it is used some places still. But it's either going to be, called a demurrer, or it's just going to be done by a motion and look like a demurrer. Got classifications. A general demurrer is a demurrer framed in general terms without showing specifically the nature of the objection, and which usually resorted to where the objection is to a matter of substance. Where's the beef? Thus, a demurrer on the ground that the complaint set forth no cause of action is a general demurrer, and a motion to dismiss a bill on the ground that there is no equity apparent on the face thereof, or that the court has no jurisdiction, is treated as a general demurrer. All right, so they're going to treat your motion like a demurrer, and these are things that are done before you give an answer. A general demurrer to an indictment challenges only matters of form and substance appearing on its face. It is one which raises an objection that averments are insufficient in law to support the actions or defenses without specifying any particular cause or defect, and is sufficient only to reach matters of substance. The federal equivalent to a general demurrer is a motion to dismiss for failure to state a claim upon which relief can be granted. Okay, it's a motion called dismiss for failure to state a claim. Well, we could try to dismiss it. What I would just as soon do is say, well, I'd rather say, how about we say that there's been indirect contempt of court because they've sued in the name of a fictitious entity. They didn't sign their complaint. Whatever. Regardless, this is what Lord Coke meant back in the 1600s when he said, point out their error early and see their last. right? Before you even answer, when you go to appear, basically, and now you're going to get the paperwork, you're going to do a motion before you do an answer. Again, I don't know what the words are going to be exactly, but you get the idea, right? We're going to say they haven't stated a claim upon which relief can be granted. We'll look at an example of that here shortly. It is one which accepts to the sufficiency of the pleadings on the opposite side and shows specifically the nature of the objection and the particular ground for the exception. Yeah, we'll show why. The federal rules analogy of a special demurrer is a motion to make a more definite and certain. To make more definite and certain. Demurrer. In pleadings, imports according to its etymology that the objecting party will not proceed with the pleading because no sufficient statement has been made on the other side, but will wait the judgment of the court whether he is bound to answer. I want a judicial determination that what they're asking for is something that the court can grant. A demurrer may be for insufficiency, either of substance or in form. That is, it may be either on the ground that the case shown by the opposite party is essentially insufficient, or on the ground that it is stated in an inartificial manner. Inartificial means real. In other words, here's the thing about law. See, everything in law, common law, English law, not chancery and the court of justice, but courts of law, it's all done by fiction. Everything's a fiction. For the law requires in every pleading two things. One, that it be a matter sufficient; the other, that it be deduced and expressed according to the forms of law. And if either one or the other of these is wanting, it becomes a demurrer. So, everything about a law is done with a fiction. That's why it's in rem jurisdiction. It's a property hearing. It isn't about people. It's about property. It's about things. It's about, stuff. Where a court of justice, being the court of chancery, that's in personam jurisdiction. That's man on man, mortal matters. Plea of the crown type stuff. Plea of the crown. What is it? It's a form used by mortals to bring a claim by living men to the king's attention. Or it's used by the king, because the king can't go directly against the subject. He's got to go through his attorney general. And who's the keeper of the king's pleas? The coroner. Protector of his property. Okay, so, we're doing things called motions, or they could be called demurrers, depending on where you are, but basically it's a way of not answering the pleading, but bringing up something ahead of time, like, court, could you take a look at this, because I don't believe they stated a claim upon which relief can be granted. And that would be a motion. But now you need to do the motion properly and get it on the motion calendar and go to the motion court so the motion can be heard by the motion judge. Not out there in, what looks like a court. This is a county of Michigan, Macon County Local Court Rules. These are the local rules approved by the Michigan Supreme Court, which govern the practice of Macon County Circuit Court. Procedures in the court are also governed by local administrative orders. For information on those, click here, right? So not only do they have Supreme Court orders, they have local administrative orders. MCR 2.119, Motion Days. Monday of each week shall be Motion Day, except on legal holiday, in which case the day following uncontested matters will be given preference over contested matters at the morning session. Filing. Counsel shall notice motions for hearing by filing a praecipe, there's that praecipe again, with the county clerk. Right? It didn't say the court clerk. It didn't say the court. You go to the county clerk. At least 7 days prior to scheduling the hearing. Now, who would have thought you go to the county clerk for a court hearing? But by God, in Michigan, Macon County, you go to the county clerk to file your praecipe. And the praecipe is basically, what they're using it for in Michigan is really just to let the clerk know to put this on the motion calendar. Praecipes are orders to the clerks to do something. The praecipe shall contain the following information, blah, 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 blah. If an order to show cause has been issued and a hearing scheduled for Monday, 7 days or more from the date of issuance, praecipe shall be filed, notify the clerk of the fact. The original must be filed with the county clerk, who shall indicate payment of the motion fee on the praecipe. If not contested, to by the opposing party a copy of the motion and brief, if any, must be filed with the judge who will hear the motion. The same procedure shall apply for any response made to the motion by the opposing party. All motions shall be scheduled for 9 a.m. unless otherwise scheduled by or with approval of the court. Opening of court. The motions will be called by the court clerk in the order as the attorneys appear. All counsel entering the court should notify the court clerk of their readiness for hearing. Dismissal for non-appearance. Motions not responded to when called by the clerk may be dismissed without prejudice 1 hour after being called. The court clerk will grant consent adjournments if notified by telephone or written stipulation. So what's the chances we've put motions in before and they've actually called your name on motion day in the motion court and you weren't there to say, "Yep, I'm here for that"? At 8:45 in the morning, the assignment clerk and respective court clerks will have posted on the main floor of the bulletin board of the court building of each court bulletin board a list of matters scheduled for the day before which judge the case is assigned. All right, so it sounds to me like you may not know until 8:45 in the morning, just before 9 o'clock, what courtroom to go to. But by gosh, if you have Monday off someday and you're in Michigan and you could go down and sit through motion day, I bet you these people are going to freak to see you sitting out there out in the pews. Right? And just kind of watch to see what happens. Who's doing what? Who's calling it out? Because that's going to be the court clerk. Know who that is now, and what are they doing? See, with these motions, I don't know if I'm going to have something up that talks about this. You're supposed to go to your brother first. It's like you're supposed to write the opposing counsel first and say, "Hey, I got an issue with this thing that you sent, blah, 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 blah." Right? They're supposed to answer you. They don't. Now you file for a motion because I went to my brother first to try to resolve the matter. I can't get him to answer me, Judge. I need your help. Do it on a motion. Hearing on other than motion day. All motions should be specifically noticed before the judge assigned to the case. Short matters may be heard on days other than motion days, promptly at 9 a.m., but only when confirmed and scheduled in advance by a judge and when properly noticed for the hearing. So if you want to do an ex parte motion to the judge, you still have to go to the county clerk, first before you go to the judge. Duty to examine the file. Counsels are charged with the responsibility of examining the court file, not the thing they gave you. What's the court using? The court file, to see that all papers necessary to the hearing are in the file, including proof of service or notice of hearing. Well, who's going to have that court file? I say it's the county clerk. All right, and you want to see the whole file, because then there's all the bits and pieces to the court case you ain't seeing. Motion certification. And all motions the attorney or party pro se shall incorporate in the request for hearing on a motion or equivalent notice or hearing certificate that the attorney or party was made personal contact with the other party or parties requesting concurrence in the relief sought and the concurrence has been denied, or that the attorney or party has made reasonable and diligent attempts to contact the other party or parties but was unable to do so. Right? That's what they're using against you right now. Hey, we tried to contact him. We used the address they got for the defendant. It didn't get to him. We're not really, he just doesn't answer. We don't have a phone number. We just have this address, but he's not answering us. Presentation for signature. Judgments and orders to which all parties have consented in writing as to form and substance shall be presented to the signature and attention of the judge through the court clerk, court officer, or judge, the secretary. You see the importance of motions and motion day. Doing this properly, right? So this is a local rule here, and I think that you're going to have to go talk to the court and say, what are the local rules for motion days? And how do I file my praecipe for my motion? And how do I make sure it's on a calendar? Right? And they say, I can't give you legal advice. You say, this isn't legal advice. This is procedural advice. It's your procedure. How does it work? I want to follow your procedure. Because motion not responded to when called by the court clerk may be dismissed. Right, so this thing we talked about before where you have to appear. Well, we know on Monday mornings at 9 o'clock they're doing motions. I wonder if on Monday you could go sit in court, and when they get all done, and they might say, hey, is there any other business today? You could say, yeah, I want to appear for a particular court case. Put in my appearance. I don't know if you can or not. These are things I'm trying to learn that we all need to figure out instead of saying that they're frickin' committing fraud and blah 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 blah. Oh my God! If that's the way you think about shit, dig a deeper bunker and polish some more ammo. Right? But just stay out of the way. Get the fuck out of the way. You're not doing anybody any good. Here's another place. Motion praecipe forms. A white form to be used for general motion praecipe and yellow for domestic relation praecipe. Additional motion requirements. Certification by attorney. The following certificate signed by the attorney of record or the party in propria persona and proper person must be placed on the face sheet of each motion filed with the court clerk's office. I hereby certify that I have complied with all provisions of whatever motion practice attorney of record. Now this says, in the county clerk's office. There we go. Another one. The county clerk. Whatever you're going to do, you're going to take it to the county clerk first. Assenting opposition contents. The moving party must assent whether a contemplated motion will be opposed. The motion must affirmatively state that concurrence of the counsel in the relief sought has been requested on a specific date, and that concurrence has been denied or has not been acquiesced in, and hence it is necessary to present the motion. So first, you have to go to your brother first. So you have to know who the attorney of record is, so you can send it to him. And they talk about you can do it by email a lot of times now, by fax, by all sorts of ways, right? All sorts of ways that you can make that connection. And if you don't hear from them, then you can put in your motion. And the original motion must be filed with who? The county clerk. Again, this is Michigan. It's going to be different someplace else, but it has to go somewhere first before it goes to the court. At the time the proceeding is adjourned, the motion must be rescheduled for a specified date and time. Okay, they said they can adjourn, I think, one time for these things. Then they have to set a specific date and time, because if they don't, it's been adjourned sin die, and they ain't coming back to it. Anytime they adjourn and they don't give a specific date and time to come back, they ain't coming back. 2119A requires filing a brief in point of law is being argued. Clearly marked judge's copy, motion brief. Okay, yeah, if you're going to bring up a point of law to argue, right, you need to file a brief, and you need to give your authorities. So one thing to remember is a book of authority used as evidence is in law in any court is considered foolproof evidence. Blackstone's is a book of authority. You can find something in there you want to use, and you put it down as your basis of law, it's going to be used because it is a book of authority. Now this one says filing a praecipe with central assignment to schedule a hearing. This is interesting. Well, whose central assignment? Ends up some places like Michigan, it's the county clerk. Right? Filing a praecipe with central assignment. Alright, so let's look at, this is in Virginia, I think. Maybe. Yeah, Virginia, in the Circuit Court of Fairfax County. Friday is motion day. Virginia, it's on Friday. This is the praecipe notice. Plaintiff and defendant, moving party, title of motion, date to be heard, yada yada yada, yada yada, praecipe, by. I certify that I have in good faith conferred or attempted to confer with the affected parties in an effort to resolve the subject of the motion without court action, pursuant to Rule 4.15b of the Rules of the Supreme Court of Virginia, and I have read and complied with each of the instructions of the moving party and the reverse of this form. Right? You need to certify that you tried to contact the other party first. And this is why the defendant, when it's you as the defendant, has a different address. So they can say we couldn't get a hold of them. And so give us that default judgment, Judge. While you're sitting out in the other room waiting for a hearing where, it's just going to be just a show. Smoke and mirrors. The assignment clerk is to be notified of hearing before, civil miscellaneous. Oh, this is a civil miscellaneous calendar. Motion praecipe. 31st Judicial Circuit Court. When motion fees have not been waived, a party must file with the county clerk a filled-in motion praecipe form 31C01. This is why it's really important to go get your county's administrative orders, your county's local court rules, your courts. Don't worry about what I'm showing here. What is it for your court? And when you find out what it is, send me an email. Say, hey, over here, this is how they do it. Hey, over here. Because, you people are too quiet, man. Nobody does anything. You listen and, hey, that's real good stuff. But you're all waiting for somebody to save your ass. What else we got here? Circuit Court motion docket. Yeah, same thing. They got evidentiary motions and non-evidentiary motions. So, I'm not going through the inner details of motions yet. I got to study it more myself, to be quite honest. But I'm pointing out, if you're into something right now, right, you need to go down. Let's say you've been in a court case already right now and you didn't do an appearance the way it said to do, so you're not getting the mail, right? Well, contact the attorney of record for the other side and say, hey, I need to have a copy of the record. I haven't gotten the mail. You're sending it to, what address are you using for the defendant? Right? Because I'm not getting the mail. Or, find out where you take your motions to and go look at the court file. It'll all be in the court file, and if you can find that certificate of pendency that says this whole thing is about $10, pay it. Be done with it. Say, clerk, I'll pay this now. Failure of counsel to appear. Automatic case management conference date may result in dismissal for want of prosecution. Blah, 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 blah. Okay. Clerk's notice dismissal for want of prosecution to all pro se parties and attorneys of record. Said notice of dismissal, last known address indicated in the file. All right, what's the last known address they got for the defendant in the file? Well, that could be the last known address as your birth address. You disappeared at some point within 7 years of birth. They ain't seen you since. You're lost beyond the sea. Every motion shall identify in its title or introductory paragraph the particular relief sought together with section of the civil procedure pursuant to which the motion is sought. Pleading motions shall not be combined with fact motions except as permitted by something or other. Improperly combined motions may be stricken by the court without hearing. No motion may be heard unless previously scheduled for a hearing on the court's calendar. This rule does not apply to genuine emergency motions. I got an emergency motion. I want to point out contempt of court. That's an emergency. The burden of calling a hearing, setting any motion previously filed, and any of the parties making a motion. The motion not called for hearing, setting within 60 days from the date it was filed, may be stricken without notice. Right? So the burden of calling for a hearing, setting of any motion previously filed is on the party making the motion. We got to make sure that our motions get on the calendar. emergency motions, emergency relief, ex parte and emergency motions, every complaint or petition brought during court hours, requesting an ex parte order for the appointment or receive a temporary restraint, preliminary injunction, or other emergency relief will be filed in the office of the circuit clerk before application to the court. If you got an ex parte motion in Illinois, you go to the office of the circuit clerk before application to the court. So before you go to the window that says circuit court, you go to the office of the circuit court, or the circuit clerk, the office of the circuit clerk first. Then you go to the circuit court window. And they'll give it to the next available judge, and you get called in, and he'll decide if he's going to grant your motion. In the Circuit Court of Cook County, County Department, Chancery Division, Court Schedule. 8:45, routine motions. 9:30, regular motion. 10 a.m., case management. This is Kent County, this is Cook County, and I think they pretty much have this guy doing this every day. All right? Room 2405, courtroom 2405, Judge Michael B. Hyman. Standing Order 2.2. Routine motions must be filed in the office of the clerk of the Circuit Court of Cook County in room 802 of the Daly Center. It's where you take your motion to. These motions should not be spindled, but should be noticed for 8:45 a.m. on any court day. Yada, yada, yada. Agreed or unopposed motion. So I'm not reading all this stuff, right? This shit's easy enough to find, right? You just go online now and put it in the Circuit Court of Cook County. Judge Michael B. Hyman's calendar. You can find it. It's not that hard. Okay. Now, I wanted to show you a particular. First of all, I'll show you some other praecipies. Motion day praecipe notice, right? The clerk of the said court will please place the above referenced case in the civil motion day docket to be called on Friday, whatever day, right? That's all the praecipe is for. It's an order to the clerk to put it on the calendar. Your motion will not be scheduled if you do not complete either one or two of the below. I certify that I have made a personal contact with somebody. I have made reasonable and diligent attempts to contact, right? If you don't do that, they're not going to put it on the calendar. Go to your brother first to settle the matter. They're following the Bible. Okay. Let's go. Okay, so let's look at some things that you could bring up. Where was that at? This is Rose foreclosure. And real quick, this is the complaint for the foreclosure, right? First of all, look at who the defendant is. Avaria Strokas and Rosita Strokavine. They do use separate names, right? But this is like Sears and Roebuck. This isn't her and her husband. This is a company, a fictitious entity that somebody's made up. They gave it an address. This mail ain't going to Roe and her husband because that isn't who they are. That's Sears and Roebuck. Complaint for the foreclosure. The plaintiff bank files a complaint. Attached Exhibit A is a mortgage. Okay, so what this is it's their statement of facts, right? Nature of the instrument, date, names on it, name of the mortgagee, Data, place, recording, identification of, what does any of this have to do with anything, right? This is interesting though. It's a fee simple, right? This says that the interest subject to the mortgage is fee simple, so we really want to win. Amount originally indebted, okay. Both legal description, yeah, okay. Just a set of facts. They haven't said what they want yet. This is just a set of facts. Yeah, that's the legal address. That's the index number. It's commonly known as this right here. Statements as to defaults, and they got some numbers in. I don't know if that's what they actually do. Name of present owners, right? So they're admitting that the name of the present owners are Roe and her husband, Avaria Strokas and Rosita Strokavine, Straskavine. Sorry, Ro. Name of other persons, name of defendant, capacity. Oh, here we go. Capacity in which the plaintiff brings this foreclosure. Plaintiff is a mortgagee pursuant to something. Now we got something to go look at now, right? They're saying the reason that they can do this is they're the mortgagee pursuant to some particular section of code. They got facts in support of redemption, statement that, okay. So anyways, it goes on, and they never really got lots of facts. Fact. Offer to mortgagee in accordance with section something or other to accept title of the real estate in satisfaction of all indebtedness secured without judicial sale is sought. No offer made. Right? They're saying they made some kind of offer pursuant to something. So what do they want? Request for relief. They want a judgment of foreclosure and sale. Okay. An order granting a shortened redemption period, if sought. Personal judgment for deficiency, if sought. An order granting possession, if sought. An order placing the mortgage in possession of appointing a receiver, if sought. A judgment of the attorney's fees, costs, expenses, if sought. In other words, they're not asking for them. They're only really asking for one thing, a judgment of foreclosure and sale. It's the only, that's the only fact as far as what they're asking. The rest of it is make-believe. And again, they're basing, beyond a bunch of facts that really have nothing to do with anything. What they're saying is the reason they can bring this claim is simply because they're pursuant to this, they're a mortgagee. Capacity in which plaintiff brings this foreclosure. Plaintiff is a mortgagee pursuant to something. Okay, let's see. Let's look at some defenses here. So here's that something, right? This is that section of law they were talking about, 15-1208, where it says, it defines what a mortgagee is. Mortgagee means the holder of an indebtedness or obligee of a non-monetary obligation secured by a mortgage or any person designated or authorized to act on behalf of such holder or any person claiming through a mortgagee as successor. So what's the mortgagee? It's either, what's a holder of indebtedness? A person or institution loaning money. Let's call them a bank. So the mortgagee is either a bank or it's an obligee of a non-monetary obligation secured by a mortgage. Okay, what's secured by the mortgage? Some non-monetary obligation. It has nothing to do with money. Okay, so it's either a bank who isn't saying that they've lent you any money. It's just a bank. Or it's an obligee of a non-monetary obligation, such as you were supposed to wash my car, such as you were supposed to close this this purchase agreement, which hasn't been done yet. Because really what's happened is your closing agent hasn't closed the damn deal yet. Right? So the thing is, my question, back to the motion now, right? So the question is, what are you? Are you 1 or 2 or 3? I need a more definitive statement of who you are as a mortgagee. Are you the holder of an indebtedness or an obligee of a non-monetary obligation secured by a mortgage, or any person designated or authorized to act on behalf of such holder, and any person claiming through a mortgagee as successor? Which one are you? Because if they say that they're a mortgage, that they're an obligee of a non-monetary obligation, well, what obligation do I have to you? I don't owe you any money. You just admitted it. What haven't I done for you, brother? And if you say you're the holder of an indebtedness, which merely means that you're a bank, because it isn't saying that they're holding your indebtedness, they're just the holder of an indebtedness, right? What do you want, bank? Do I owe you any money? You're not claiming any money. What indebtedness do I owe you? Okay, and then the other one was they had used some particular words in what they wanted here. A judgment of foreclosure and sale. So I took judgment of foreclosure and sale, those words just like it is, and I went and I searched Illinois' judgment of foreclosure and sale. And it only shows up in one statute. And that statute is 1505.8. The motion requesting an expedited judgment of foreclosure and sale may be filed by the mortgagee at the time the foreclosure complaint is filed or at any time thereafter, and shall set forth the facts demonstrating that the mortgage real estate is abandoned residential real estate under section 1200.5 and shall be supported by an affidavit. They have to swear to the fact that the house is abandoned. That's what they're asking for. Well, the house isn't abandoned. They've already said further up here that you're the owner. Not you, Ro and her husband. They're the owners. Name of persons, name of present owners of said premises. Ro and her husband. It gives the address. Well, they're living in it now. And so my point is, for them to make this claim, they had to had said that the property is already abandoned and put in an affidavit. So you ask them, well, where's the affidavit that shows that the property is abandoned per your requested relief? Otherwise, you've asked for a relief. You've stated a claim upon which relief cannot be granted. So that's the motion. Now again, I don't know how to do these motions exactly, but you get the point, right? It's real simple. You look at what they've said. See, when somebody starts writing shit, they box themselves in. Everything you write, every statement you make is one more boundary you've set for yourself. That's why you want to say as little as you can. Let them do all the talking and set their own stakes, their own boundaries. Boom, 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 boom. And you just go back and start reading them. Okay, well, what'd you say? Because they're not seeking any of these other ones. If sought. The only one they're seeking is one they can't have. They've stated a claim upon which relief cannot be granted. Now. Mail, name, procedure from law clerk. Civil motion is scheduled 9 a.m. I think the only reason I had this here, judge's copies may accompany a filing sent directly to the judge's law clerk at, okay. I thought maybe the law clerk was making these things up, right? Because this is like, the local administrative rules. Who's responsible for the local administrative rules of the court, and where do you get a copy of them so that you can do the motion properly? And one other thing I want to show you real quick. I just remember where this thing is, because we're going to do a whole nother video on this, but I want to show you something that is worth taking a look at. Roe got an arrest warrant against her. And this arrest warrant, because they came to her house and they didn't have the warrant. They wouldn't give the warrant, wouldn't show her the warrant. Just you're under arrest and you got to pay some money or we're going to take you to jail. And so they gave this to her after she was leaving court. Let's just take a quick look at what an arrest warrant says. I had never seen one before, so it's a good one to look at. You are hereby commanded to arrest the defendant designated herein and bring the person without unnecessary delay before a judge of the Circuit Court for the 16th Judicial Circuit, Kane County, Illinois, in the courtroom in the city and or village designated herein, or in absence or unable to act before the nearest and most accessible court in the county to answer a charge made against said person in violation of Illinois compiled statutes set forth. You are hereby directed to hold said person to bail in the amount set forth herein. But they're supposed to take you to court. And they didn't take her to court, they took her to jail. We're going to put you in jail if you don't pay the bail. They didn't do they didn't follow the arrest warrant. But here's the wonderful thing. See how they got her name? Straskovine Rosita. Last name, first name, address, right? Street address, city, state. There's one problem. This isn't her zip code. 60175-0000 plus 40000. It's not hers. Neither is 60175. Hers actually, I think, 60174. It's not 60175. So if you put in 1903 Rita Avenue, St. Charles, Ill, into Google, it will give you the address for Roe, and it will give you the correct zip code. But this stuff here is all, generated from the computer. So who gave her a zip code of 60175-000? That, to me, would be tampering with the mail. Right? So that's the way her name is. Now, this warrant was supposed to be because she had not shown up for a preliminary hearing, and so that should have been, like contempt of court for not showing up. Didn't show up. Promised to appear. Didn't show up. And what it was jury selection day. But that isn't what this warrant's for. This warrant's because of a complaint that this Sandy Wegman put on her back in August 7th. Sandy Wegman's the recorder. And Roe was saying, well, how come you're charging me this for this recording when it says in the law this is what you're supposed to charge me? Well, Sandy didn't like that. She didn't want to have to answer it, so she put in a complaint. And her complaint, the words of her complaint from her were the words that came out of the statute, exactly what the statute says. There was no complaint against Roe. Her complaint was based on a definition. Anyway, they got Sandy's name, Sandy Wegman. They got Rose backwards. They got Rose with a zip code that isn't her zip code. That's crazy. This is something to take to somebody like conservator of the peace. Say, there's an insurrection going on or something. Somebody's disturbing the peace. Somebody is tampering with the mail. Because, this is computer generated stuff. So, is there any other paperwork that went to this address that doesn't exist that goes to this court case that Roe hasn't seen? Because it doesn't exist. At least it's not going to come to her. I'm not saying it doesn't exist in their system, that this zip code exists, and anything that has this zip code on, doesn't matter what the address is going to go to a particular post office box. Or, a particular office or something else. Because a lot of times with the +4, at the end, it's to a particular P.O. box or something like that. Like the postmaster has one, and the post office has one, and a lot of post office boxes have them. So where does 0000 go? Because if that was the case and they're only looking at the zip code, doesn't matter what the rest of it is, it's going to go to that post office box. And that's tampering with the mail. That's what I think. So, okay. Well, anyways, that's about all I had. About all I can take for right now. I got to figure out how I can put these two videos together. Motions, very important. Appearance, very important. Again, it looks like you could do an appearance and not. You're going to do nothing but do an appearance so that you can get copies of the paperwork. Because if you don't appear and give them an address, they're going to use the address they have for the defendant, and it ain't going to come to you. All right, so you want to make yourself the attorney of record for the defendant. Because the defendant isn't you anyways. The defendant is property. In your book, the living person is, or in their book, the living person is, in my case, Rytlewski, Robert Allen. All right, just like they had Rose. Rytlewski, Robert Allen is the owner of Robert Allen Rytlewski. The following is a copy of record of birth of Robert Allen Rytlewski, now remaining in my office. It's owned by Rytlewski, Robert Allen. Because I haven't changed my name, I haven't accepted the surname. Possibly. So. Okay, we'll leave it there. Y'all have a great night.